Presiding Officer, it is axiomatic that a referendum must be lawful. But my deliberations in recent times have led me to this further conclusion. The lawfulness or otherwise of the referendum must be established as a matter of fact, not just opinion. Otherwise, as we have seen again in recent days, opposition parties will just keep casting doubt on the legitimacy of the process so that they can avoid the substantive debate on independence which Scotland deserves, but they so clearly fear. That is not in the country's best interests. Let me turn then to the detail of the steps we will now take to secure that objective of an indisputably lawful referendum, and then ensure that from today we can focus on the substance of why Scotland should be independent. Presiding Officer, I can announce, first of all, that the Scottish Government is today publishing the Scottish Independence Referendum Bill. I will draw attention in particular to three key provisions of this bill. Firstly, the purpose of the referendum, as set out in Section 1, is to ascertain the views of the people of Scotland on whether or not Scotland should be an independent country. In common with the 2014 referendum, indeed in common with the Brexit referendum and the referendum to establish this Parliament, the independence referendum proposed in the bill will be consultative, not self-executing, just as in 2014 and recognised explicitly in the 2013 White Paper. A majority yes vote in this referendum will not in and of itself make Scotland independent. For Scotland to become independent following a yes vote, legislation would have to be passed by the UK and Scottish Parliaments. Now, there has been much commentary in recent days to the effect that a consultative referendum would not have the same status as the vote in 2014. That is simply wrong, factually and legally. Let me be clear. The status of the referendum proposed in this bill is exactly the same as the referendums of 1997, 2014 and 2016. The next provision of the bill I wish to draw attention to relates to the question to be asked in the referendum. The bill states that the question on the ballot paper should be, just as it was in 2014, should Scotland be an independent country? Finally, Presiding Officer, the bill includes the proposed date on which the referendum should be held. In line with the Government's clear mandate, this is a date within the first half of this term of Parliament. Presiding Officer, I can announce that the Scottish Government is proposing that the independence referendum be held on the 19th of October 2023. These are...
Thank you. Thank you. Members.
These are the key elements of the referendum legislation that the Scottish Government wishes this Parliament to scrutinise and pass. Let me turn now to the aim of establishing as fact the lawfulness of a referendum, which, as I have already indicated, I consider to be of the utmost importance. I will start with what we know already. We know that the legislative competence of the Scottish Parliament to pass this bill in the absence of a Section 30 order is contested. We know that legislative competence can only be determined judicially. And we know that for as long as there is no judicial determination, opinions will differ and doubt will continue to be cast on the lawful basis for the referendum. That benefits only those parties opposed to independence, because it allows them to avoid the substance of the independence debate. Finally, we know that if this Parliament does seek to legislate without a Section 30 order, the bill will go to court. That is inevitable. The only questions are when it ends up in court and at whose hand. If the issue of legislative competence remains unresolved at the point of formal introduction of a bill, the UK Government will almost certainly use Section 33 of the Scotland Act to refer it to the Supreme Court after it has passed. It is also possible that one or more private individuals will lodge a judicial review of the bill. Indeed, it was reported last week that Tory supporters are already planning to do so. A challenge by private individuals could also go through successive courts and so be a very lengthy process. Either way, at the point of Parliament passing the bill, there would be no certainty about when or even if it could be implemented. A court challenge would still lie ahead, and the timetable I have set out today would quickly become difficult to deliver. And of course, between now and then, claim and counterclaim, good faith arguments and bad faith fear-mongering about so-called wildcat referendums will continue to muddy the water, cast up doubt and taint the process. Presiding Officer, that may well suit politicians opposed to independence, but none of it would be in the interest of the country and none of it would serve democracy. The fact is, neither legal opinions nor political arguments will resolve this point. We must establish legal fact. That is why, in my view, we must seek now to accelerate to the point when we have legal clarity, legal fact. And crucially, in doing so, I hope, establish and safeguard the ability of this Parliament to deliver a referendum on the date proposed. Presiding Officer, it is to this end that some weeks ago I asked the Lord Advocate to consider exercising the power she has under paragraph 34 of Schedule 6 to the Scotland Act to refer to the Supreme Court the question of whether the provisions in this bill relate to reserved matters. This is a power exercisable by the Lord Advocate alone, not by Scottish ministers collectively. Whether or not she does so is accordingly a matter solely for her. However, I can confirm that the Lord Advocate has considered this request. She has taken into account the following factors: this Government's democratic mandate, the constitutional significance of this issue, the fact that the bill does raise a genuine issue of law that is unresolved, and the importance of ensuring that this Government and Parliament act lawfully at all times. And she has now informed me of her decision. I can advise Parliament that the Lord Advocate has agreed to make a reference of the provisions in the bill to the Supreme Court. Indeed, Presiding Officer, as I speak, the process for serving the requisite paperwork on the UK Government by lawyers and messengers at arms is underway, and I can confirm that the reference will be filed with the Supreme Court this afternoon.